Hi, welcome. Hi, everybody, and thanks for attending. The webinar today concerns, as you know, the fight against money laundering and terrorist financing. Before, I would like to thank UIA, the Union Internationale des Avocats, to organize this webinar and my fantastic team of speakers. I remember that UIA is a global organization for the legal profession, and UIA is established in 1927. I think that we can start with our webinar. As you know, the speaker, as indicated in the program, will describe the impact of money laundering and terrorist financing on different sectors. And the speaker will describe also the impact of COVID-19 pandemic on the measure to combat these crimes. My name is Barbara Bandiera. I am the president of the UIA Compliance and Anti-Money Laundering Subcommittee. The fight against money laundering and terrorist financing is a topic that is very relevant for our organization. I think that can be interesting with our presentation. Okay, I can use the slide, Colette. Okay. I will introduce money laundering and terrorist financing, and I think that can be very interesting to start with the definition of this crime. Okay, the first slide, money laundering. Please note that money laundering is the processing of assets generated by criminal activity to obscure the link between the fund and the illegal origin. Terrorist financing involves raising funds to support terrorist activity. Other relevant definition for our webinar is terrorism. I like you that there is not an international definition of terrorism that has been accepted, but we can use this definition that you can read in the slide, because this is, I think that is an official definition, because it's the definition used by the European Commission. Terrorism can be defined as the use of action designed to provoke terror in the public. Terrorism is the act of an individual or a group of individuals acting in their individual capacity or with the support of a state. But terrorism is also the act of a state, whether against the population, for instance, in the case of deportation or genocide, or in the context of international armed conflict against the civil population of the enemy state. Before I say that money laundering and terrorist financing are crimes. In particular, money laundering and terrorist financing are financial crimes with economic effect. Effective anti-money laundering and combating the financing of terrorist regime are essential to protect the international financial system. Therefore, action to prevent and combat money laundering and terrorist financing respond not only to a moral imperative, but also to an economic need. In this speech, that is an introduction to money laundering and terrorist financing, I would like to give some input about this crime and the different sectors in which this crime impact. Before I say that are crimes, and in particular are financial crimes. So in the next slide, I highlight you the link between the financial crimes in times of COVID-19. COVID-19 pandemic has led to unprecedented global challenge, human suffering, and economic disruption. Criminals are exploiting vulnerability opened up by the COVID-19 lockdown, increasing the risk of money laundering and terrorist financing. Please note that in this moment, the role of financial institution is very, very, very important, because the financial institution have to mitigate these money laundering and terrorist financing risk. They have to be vigilant of new emerging risk. They have to continue meeting AML and CFT requirements, but at the same time, they have used flexibility built into AML, CFT risk-based framework, digital customer onboarding, and simplified due diligence process. Other slide that concern always the COVID-19. I think that that is interesting to know that As a large number of people around the world remain locked down and spend more time online, terrorists are adjusting their approach and appeal to try to radicalize and recruit individuals to terrorism and incite violence. I spoke of finance. I think that's interesting to speak also of Islamic finance. What is Islamic finance? Islamic finance refers to the provision of financial service in accordance with Sharia Islamic law, principle and rule. But please note that in this moment there is no common understanding of money laundering and terrorist financing risk associated with Islamic finance. Why? For the complexity of some Islamic finance products, for the nature of the relationship between the institution and the client, but also for the limited capacity and experience in the supervision of Islamic finance. I think that you know the role of a Financial Action Task Force. A Financial Action Task Force, or GAFI, is a very important body that fights against money laundering, terrorist financing, and I think that you know also the Financial Action Task Force recommendation. And these standards are implemented without any form of tailoring to the specificity of Islamic finance. It is important that we understand the Islamic finance and the possible link with money laundering and terrorist financing. I spoke of conventional finance, I spoke of Islamic finance, but there is another finance that is very relevant in this moment, the sustainable finance. Sustainability is a very topical issue in this moment. But we have to study for this webinar the link between illicit financial flow and sustainable development. Illicit financial flow refers to the movement of money across border that is illegal in source, for instance, in the case of corruption or smuggling, its transfer in the case of tax evasion, or its use in the case of terrorist financing. Illicit financial flow constitute a major disable to sustainable development, and they can have a direct impact on a country's ability to raise, retain, and mobilize its own resources to finance sustainable development. The Sustainable Development Goal call country to reduce illicit financial flow, to reduce illicit harm flow, and to reduce corruption and bribery in all their form. I like to use this word, harm, illicit harm. In the next slide, I describe the illicit arm trafficking, that is a dangerous crime that fuels conflict all over the world. Illicit arm trafficking is a dangerous crime, is a predicate offense for money laundering, but also a source of terrorist financing. Traffic arms become instruments that enable terrorist attack, and terrorists may also be involved in illicit arm trafficking to fund their operation. Other input, after there is a speech of Gustavo that concerns human rights, I give in the next slide only some input to introduce also the link between the money laundering, terrorist financing and the human rights sector. For instance, a great problem is the financing of ethnically or racially motivated terrorism. I don't know if you remember, for instance, the attack of Christchurch in New Zealand in 2019. This attack highlighted the importance of raising awareness and further analyze this crime. Other problem that is linked with the human rights is the migrant smuggling or smuggling of migrants. That is a transnational organized crime that continues to generate significant revenue for criminal network, and in particular for terrorists. But the problem is the terrible human cost of this type of crime. Other problem, the victim of acts of terrorism, women, men, girls, boys, children, all. I think that you can think to, as example, to hostage taking, explosive attack in public place, or airplane hijacking. I think that another important topic is the relation between the women and terrorism, because terrorist groups target women through acts of sexual and gender-based violence, such as rape, sexual slavery, and forced marriage. Many terrorist groups encroach on women's human rights and impede their socio-economic development. including by restricting their movement. This is very dangerous for women. But I like to also that some women actively voluntarily support a terrorist group. But please note, read at the end of the slide, this is very relevant, because in some conflict, women become associated with the terrorists, but through coercion or abduction. And may commit terrorism-related offense, but at the same time, women are victims of violence by terrorist organizations. Another topical question, another topical issue in this moment is illegal wildlife trade. That is a transnational organized crime. Recently, the Financial Action Task Force published a report about this crime. Please note that this crime fuels corruption, threatened biodiversity, and can have a significant negative impact on public health and the economy. The problem is that wildlife traffickers exploit weaknesses in the financial and non-financial sector and in the different jurisdictions. And the other problem is that jurisdictions rarely investigate the financial trail left by this crime. It is relevant to study also this crime and the link with financial crime. Last slide and the last input after I give the floor to my fantastic team of speakers is the drone. The official name of drone is Unmanned Aircraft System. And please note that terrorists use drone to conduct attacks, but also in support of surveillance, reconnaissance, and propaganda activity. I conclude with the two key words of the title of this webinar: challenge and priority. Money laundering, terrorist financing are global threats that know no border, nationality, or religion. Money laundering, terrorist financing continue to be a challenge around the world that international community must tackle together. The other relevant word for our webinar is priority. The international community has made the fight against money laundering and terrorist financing a priority. I indicated in the slide the goal of this effort that are protecting the integrity of the international financial system. I remember that at the beginning of my speech, I said money laundering and terrorist financing are financial crimes. Other goal, cutting off the resource available to terrorists. And another important goal is the following: making it more difficult for those engaged in crime to profit from their criminal activities. So I conclude my speech. That is an introduction. And thank you very much for your attention. And I give the floor to Etienne Lesage, that is my second, that is the first speaker after my introduction. Etienne Lesage, I like to that is the president of the UIA Criminal Law Commission, and he's French. He's working in Paris, and he's partner of Lesage Avocats. I would like to indicate the key point of the speech of Etienne, because Etienne is a criminal lawyer, and so Etienne described the impact of money laundering, terrorist financing in the criminal sector with a criminal point of view. The key points are the international definition of money laundering and terrorist financing, the international recommendation in regard to the legal privilege, and I thank you, Etienne Lesage, in particular also for this key point, because I know that for lawyer is very interesting this topic, the legal privilege. And the last key point of the speech of Etienne Lesage is the 5th Anti-Money Laundering Directive and the French illustration. Okay, thank you, Etienne.
Thank you very much, Barbara. So, money laundering and combating financing of terrorism is always a hot topic of topicality, if I can say. Let's illustrate the subject with a French example as a brief info to show how this topic is actual. The government of France issued an ordinance which transposes the EU fifth directive of May 2018 of the European Parliament and the Council, known as this fifth anti-money laundering directive. And it was transposed in the French law by this ordinance of February 12, 2020. So it's really recent, and it's asked and pose questions concerning the role of lawyers, the privilege, the legal privilege, and the secrecy that we benefit. You know, in this matter, in this international topic that has an international definition, as you said, Barbara, there are no frontiers to money laundering and terrorism. Of course, the international community has made the fight against money laundering and the financing of terrorism a priority, as you said. And as we all know, among the goals of these efforts are protecting the integrity and stability of the international financial systems. I'm not going to insist on that. But let's have a look at these different international definitions given by the IMF, given by the United Nations, given by the World Bank, and given by the Gafi, the Financial Action Task Force, that will study some of its recommendations and the link with this recommendation with our legal privilege. That's the point of view of a criminal lawyer. According to all these international definitions, money laundering requires an underlying primary profit-making crime, such as corruption or bribery, drug trafficking, market manipulation, fraud, tax evasion, along with the intent to conceal the proceeds of the crime or to further the criminal enterprise. Money laundering, like bribery, costs billions and billions of dollars, and represent a significant percentage of the global economy. This percentage is not really known. It varies, you know, from 1 to 10%. No one knows the amount of the fraud, but it's a significant percentage of the global economy. And these activities generate financial flows that involve the diversions of resources away from economically and socially productive issues. These diversions have negative impacts on the financial sector, of course, and external stability of the different states. They also have a corrosive, corrupting effect on society and the economic system as a whole, because of the negative consequences of this form of financial abuses. Briefly described, money laundering is the process by which proceeds from a criminal activity are disguised to conceal their illicit origin. More precisely, according to the Vienna Convention of the UN against illicit traffic in narcotics and drugs from 1988, and the Palermo Convention, and other UN convention from 2001 against transnational organized crime, provisions on money laundering, it may encompass 3 distinct alternative actu reas. First, the conversion or transfer, knowing that such property is the proceeds of crime. Second, the concealment or disguise of the true nature, source, location, disposition, movement, or ownership of all rights with respect to property, knowing that such property is the proceeds of crime. And third, the acquisition, possession, or use of property, knowing at the time of the receipt that such property is the proceeds of crime. The international standards for the fight against money laundering and the financing of terrorism has been established for many years by these main international organizations. Let's have a focus on the GAFI, the Financial Action Task Force, FATF. This is a group of 33 member states established at the G7 summit in Paris in 1989, with the primary responsibility for developing a worldwide standard for anti-money laundering and combating terror. And it's very important because it summarizes all the principles and all the definitions that we can give. What is financing of terrorism? Terrorist financing involves the solicitation, collection, or provisions of funds with the intention that they may be used to support terrorist acts or organizations. Funds may stem from both legal and illicit sources. And it's always the link between legal and illicit sources that are mixed by the fraud or by the terrorist or the one who finance them, that it makes it very difficult to apprehend. More precisely, according to the International Convention for the Suppression of the Financing of Terrorism, a person commits the crime of financing a terrorism is that if that person, by any means, directly or indirectly, unlawfully or willfully, provides or collects funds with the intention that they should be used, or in the knowledge that they are to be used in full or in part, in order to carry out an offense within the scope of the convention. The primary goal of individuals or entities involved in the financing of terrorism is therefore not necessarily to conceal the sources of money, but to conceal both the financing and the nature of the finance activity. Efforts to combat money laundering and financing of terrorism are linked. Money laundering is a process of concealing the illicit origin of proceeds of crimes. Terrorist financing is the collection or the provisions of funds for terrorist purposes. In the case of money laundering, the funds are always of illicit origin, whereas the case of terrorist financing, funds can stem from both, as we said, legal or illicit sources. And similar methods are used for both money laundering and the financing of terrorism. In both cases, the actor makes an illegitimate use of the financial sector. The techniques used to launder money and to finance terrorist activities are very similar, in many instances identical. An effective anti-money laundering counter-financing of terrorism framework must therefore address both risk issues. It will prevent, detect, and punish illegal funds entering the financial system and the funding of terrorist individuals, organizations, and/or activities. So the Financial Action Task Force has defined 40 recommendations that we are not going to study or even to list, because that would take, you know, the whole evening and night to come. But these recommendations are important to consult, because it defines what countries should do to prevent money laundering and terrorism, what international institutions should do in the same purpose, and what the member states of this international convention must do as well, as a cooperation, as international cooperation to define standards and sanctions against this action. If we give some examples, you know, the recommendations of the FETA precise that countries should have national anti-money laundering, combating funding of terrorism policies. They must criminalize, of course, money laundering on the basis of the Vienna and the Palermo conventions. They must adopt measures to enable their competent authorities to freeze or seize and confiscate the following without prejudicing the rights or the bona fide third parties. They must have laws that defines terrorist financing offense. They must have targeted financial sanctions related to terrorism and terrorist financing. They should implement targeted financial sanctions regimes to comply with the United Nations Security Council resolutions relating to the prevention of this topic. And they must also point the non-profit organizations that countries should review the adequacy of laws and regulation that relate to non-profit organizations which the country has identified as being vulnerable to terrorist financing abuse. On the other hand, on the following, financial institutions, following these recommendations, must establish and related to customer due diligence. They must prohibit from keeping anonymous accounts and accounts in obviously fictitious names. They should be required to undertake customer due diligence measures when establishing business relations and carrying out occasional transactions above the applicable designated threshold, US or Euro 15,000, or that are wire transfers in the circumstances covered by the interpretative recommendation of the Financial Task Force. There are additional measures for specific customers and activities, that is, politically exposed persons, correspondent banking related to money or value transfer service. Therefore, countries and international financial institutions designate non-financial businesses and professions, among them, of course, lawyers. Among them, and mainly, I can say, lawyers, because lawyers, notaries, or other independent legal profession, given the name they have in different countries and different law system, when they prepare for carry out transactions for their client concerning the many activities like buying or selling of real estate, managing of client money, securities, or other assets, managing of bank, savings or securities accounts, organization of contributions for the creation, operation, or management of companies, etc. What are they subject to anti-money laundering reporting obligations? One of the most frequent reasons given by us lawyers is that not to report certain financial transaction to a financial intelligence unit or to a state or to the government is inconsistent with and would undermine legal privilege. However, privilege does not cover advice obtained from lawyers for a criminal or fraudulent purpose, of course, or in case where the advice is sought that has nothing to do with legal advice, such as asking a lawyer for business advice, valuation advice, or when using trust accounts as a deposit-taking institution, depositing funds in a trust account for banking purpose to avoid using a bank. In France, you think of the CARPA, the lawyer's bank, for money transfers. And yes, if it happens, it has to be inconsistent with the rules governing lawyers. But we have different consideration for this legal privilege. As you know, in countries of Roman Germanic tradition like France, the protection of legal opinions and documents which support them is only guaranteed by virtue of the professional secret for lawyers, professional secrecy. In common law countries, it's a very different concept which prevails since in-house lawyers also benefit from legal privilege that we don't have legal. We have in-house counsel in France, but they are not covered by the legal privilege yet. And since the content of the communication is more important than the author of the recipient, as in the case for the professional secret for lawyers, which is based upon approach in personam to confidentiality. In essence, the law of privilege is that communications received by lawyers or advice given that is within the ordinary scope, professional engagement is protected and its disclosure cannot compelled in any court of law or equity. Another way of saying is that while there is a privilege protecting communications between the lawyer and the client, it disappears if the relationship is abused. And especially when you have to deal, when you have to set up a money transfer. So this is our activity of legal advice opposed to the activity of pleading and going to court. But in France, when we had the third directive in 2005, we had the filter of the president of bars, who are the authority who receive the suspicion of a lawyer if he thinks that the transaction he is asked to perform or he is hired for is suspected of money laundering or funding an activity linked to terror. We had the Michaud from the European Court of Justice. We had another important decision concerning the Belgian state made in 2017 by the European Court that defines the protected areas that lawyer can act for without declaring their suspicions on activities linked to money laundering. And that's always a very delicate question, this law of privilege, and how we have to deal with the combination of the interests of our client without being their accomplice, without participating to the fraud. We till now, and to hand because I am too long. To hand with the European regulation. We have the third directive in 2005, the fourth directive, and now in 2018, the fifth directive. That is a threat as well to our legal privilege or professional secrecy. But we have the laws that, according to what we saw with the international regulation of the Financial Task Force.
Can I have to ask you if you can conclude, because we are not in time.
Yeah. Okay. All the laws that we implement in our internal legislation in Europe and in all industrialized countries are the same. Combine the interest of the states and the global economy with the respect of the professional secrecy that has to be maintained in the interest of everyone. So very delicate questions, always a paradox with the link between fraud and liberty.
Okay, thank you very much for your speech, Etienne. I ask you to my speaker if they can read the question that we have on the right of the PC, because there are two considerations. The first consideration is the following. Money, can you read the question? Okay, the first consideration is the following. Money in the name of charity, greater concern for countries says it is something related to money laundering and aiding terrorism for some times. I agree with this consideration, because a great problem in this case, money in the name of charity, is the use of crowdfunding platform. I like you that the Financial Action Task Force publish some cases of the usage of crowdfunding. For instance, a project to aid children that are in Syria, but the real objective is the money laundering and terrorism purpose. So I agree with this consideration. I don't know if my speaker have some consideration about this point. No. There is another question. This is a particular question, and I ask you to Yoncha or Silvestre, that are financial lawyer in particular, if they are interested to reply this question that is very particular. The question is, do you agree that all banks around the world, particularly compliance departments, are working as an officer for OFAC favor? Sorry, Silvestre, are you using the mute? Silvestre, the mute. I think that you have the mute.
Barbara, I can ask a question. Yes, it does, because you know, based on within the framework of banking approach, if the bank assure the compliance officer, I think, in my opinion, bank doesn't follow the banking or the another for instance payment services activities, whether it's compliance with the CDD or not. For that reason, I think it must.
But in your opinion, the compliance department are working as an officer for OFAC favor? OFAC, the Treasury Department of the United States.
Oh, okay.
No, in my opinion, I do not agree with this consideration, because I think that the money laundering and terrorist finances are a global problem, and I think that each state is not an officer for OFAC, but I think that we are. I think that the international community must tackle together this fight against money laundering and terrorist financing. Because yes, OFAC is very important. I remember the list of OFAC about the terrorists, but there are many organizations that in the world work to fight against money laundering and terrorist financing. For instance, the United Nations, also the World Bank, the Financial Action Task Force, the World Bank. This is my opinion. This is my personal opinion, but I understand also the opinion of other colleagues. I don't know if Silvestre
oui, je crois que le son est revenu. Do you hear me now, Houston? I think we have to make a distinction. If the bank has been fined, and when the bank has been fined by extraterritorial sanction from US sanction, for example, then the compliance officer has to closely report to the OFAC. So it's, but if it's not the case of the bank, then it's different.
Okay.
And for example, you have for a French bank that has been fined, the famous one, they had to support about I think more than 10 people from OFAC inside the bank and inside the conformity department.
Yes,
paid by the bank.
Yes, in my opinion, I think that bank have to observe the law, but I think that banks are not officer of OFAC. I don't think. But this is my this is our opinion. Okay, it is important to have also different opinion. I think so we can discuss during this webinar. So the other speaker is Gustavo Salas Rodriguez. Gustavo Salas Rodriguez. He comes from Mexico, from Cancun, and he is co-director of the Human Rights and Protection of Lawyer, UIA IROL. Please note for the non-member of UIA, I remember that IROL is very relevant institute for our organization. And I invite you to see our website of the UIA and to read also the action of UIA IROL. Gustavo is also partner of Salas Asociados. The speech of Gustavo concerns the human rights, and I would like to highlight you that Gustavo is the professor of human rights at the Universidad Iberoamericana of Mexico City campus. And I would like to indicate the principal point of the speech of Gustavo. These are the following: terrorist financing and forced displacement, humanitarian law and the situation of the wife and children of ISIL fighter, money laundering, and third and fourth generation human rights. Thank you, Gustavo. You have the floor.
Thank you, Barbara. Good afternoon. We are nearly 7.8 billion people in the world. Besides the extreme violence produced by terrorism against civilian targets, enforced displacement is another kind of such violence that impacts more than 1% of the world population. Approximately 79.5 million people are uprooted today. More than half of the uprooted are conformed by children. In some cases, like those of the children or women of the Islamic State fighters or ISIL, the acronym for Islamic State of Iraq and the Levant, the enforced displacement comes from their very own villages. In many cases, wives and children of ISIL fighters were themselves victims of ISIL's violence and may have been coerced into facilitating crimes. However, it has been reported that judges and prosecutors have not taken these mitigating circumstances into account. Let us see a short video from 2018, which due to the pandemic is like last year, but I think we have some audio problems, so fortunately it has subtitles. Let us see. Well, this is about the tragedy of the enforced displacement. And of course, of the hideous conditions they suffer. We have to consider that for every 1,000 people that has to flee, there are 1,000 people that have been murdered by terrorism. These numbers are very frightening. Well, this is figures from 2018. In a decade, the numbers of the refugees grew from 40 million to almost 80 million in one decade. These are the 5 main countries with refugee problems: Syria, Afghanistan, South Sudan, Myanmar, Somalia, and of course, now Venezuela. And of course, the problem is, how can we help these refugees? Sorry about the audio of the video. When an immigration matter arises, Professor De Luca from the University of Valencia uses to evoke the story of the Babel Tower. According to Robert Graves, Noah's descendants traveled from land to land, slowly moving towards east. They settled in the land of Sennaar. After 20 years, a war started. Sennaar was conquered by Nimrod, the son of Cush, who swore vengeance upon he who drowned his ancestors. So he started to build a tower, high enough to resist another biblical flood. But the construction conditions were unfair. If a brick fell, everyone would suffer punishment. But if a man fell and died, nobody cared. Thereafter, 70 angels were sent to spread confusion among men by making 70 languages out of one. The misunderstandings started. When a constructor asked an apprentice for something, the apprentice brought something else. That made the constructor so furious that he simply killed the apprentice, and so on. Due to such confusions, many were the murders committed in the tower, leading to the abandonment of the construction, and the men dispersed across the world. Confusion. Terrorism also nurtures itself with confusion. The confusion that led some communities to nullify women's dignity or their rights. In such a context of gender inequality, do ISIL fighters women have reasonable choices? Anyhow, terrorism, and therefore financing terrorism, produce internally and externally enforced displacements. Then the borders close for the uprooted. Victims of terrorism themselves, and for that, are entitled to protection and reparation. Human rights for humanity, but not for certain humans. The message of social emergency consists in proposing that the presence of foreigners is equated with other alarms or pathologies, such as crime or drugs. Racism appears as a byproduct. For example, early attempts to explain ISIL's appeal to women tended to portray them simply as jihadi brides traveling to the conflict zone looking for romance and adventure. In recent public discussions, there has been much loose talk of terrorists hiding in large numbers in refugee streams. This has made many people apprehensive about offering asylum seekers the assistance they are entitled to from countries which have signed and ratified the Convention and UN protocol relating to the status of refugees, the uprooted. Simone Weil points out that rooting is perhaps the most important and, at the same time, unknown need of the human being. The human being roots through their active and natural participation in a community. Natural means that it is given by place, birth, work, and environment. Uprooting is, in the long term, the worst disease of human communities. All this violence, the social and even family violence, lead us to remember what Habermas has said. Whoever destroys the internal connection between the issues of political asylum and immigration for reasons of poverty implicitly declares that he wants to get rid of Europe's moral obligations towards those evaded from the most miserable regions of this world. It is the political community that guarantees, that makes possible for individuals the basic right, which is the right to have rights, the foundation not only for freedom, but above all, for equality. That right is the one that is denied to the refugee, to the women of ISIL fighters, to the children. Ultimately, as Adela Cortina says, there is no xenophobia, but aporophobia, the rejection of the poor. Thank you.
Well, thank you very much, Gustavo, for your speech. I ask you if you can say only 2 words, but about UIA role, because UIA role is very important institution for our organization. So if you would like to say 2 words about UIA role, I'm very happy for this.
Of course, thank you, Barbara. The IROL, or the Institute for the Rule of Law, enforces itself almost every day, trying to make notice of what is happening in, worldwide, related to attacks to the independence of the profession, or even to the professional activities itself. We have so many cases around the world of lawyers harassed, intimidated, or imprisoned just by being defenders or in the human rights arena. So any effort that we make is not enough for having an impact against authoritarianism, against the lack of the rule of law in some places. I want to just, for ending, to remember the words of Martin Luther King. An injustice in any part of the world is an injustice for all the world.
Okay, thank you very much, Gustavo, for your speech. And the other speaker is Silvestre de MARSAC. He is a French lawyer, and Silvestre is co-founder and partners at FTMS. It is important, very important law firm in Paris. And in this law firm, he is the head of the banking and finance department. The speech of Silvestre concerns the financial point of view, financial and banking point of view. Please, Silvestre, you have the floor.
Yes, thank you, Barbara. On a le son là, c'est bon?
Oui, c'est bon.
Voilà. Donc, and thank you, Etienne and Gustavo, for those presentation. And I think the question is how to combat money laundering and the financing of terrorism. And Gustavo, show us why it's a challenge and a priority. And I try to give you some example of cases of money laundering, because if you want to fight to combat money laundering and the financing of terrorism, you need to know how do the money launderers organize themselves, and to be able to detect example of money laundering scheme or terrorism financing scheme. One of the recent most famous case of money laundering, it's direct connection with the former presentation, because the goal was to escape payment of taxes. It's called Villa d'Hier case. The Villa d'Hier case was purchased under a nominee for underdeclared amount, officially bought for 35 million euros. But in fact, the value of the good was 150 millions. And the part of the price was officially paid up to 35 million euro. And then the difference between 150 million and 35 million euros was paid offshore via offshore companies. I have to say, and that the French police and tax authority taped one of the lawyers who organized the operation, and could detect the fraud, and then sue the author of the fraud. But it's of course, you will tell me it's more connected with tax evasion than money laundering, but in fact it was both tax evasion and a way to blanchir l'argent provenant d'activités non déclarées. Next, please, Colette. Then you have the some online financial institution. Of course, they are subject to the AML CFT policies, but we have two cases, two recent cases where you see how the individual can use financial institution to illegal financial circuits. Next, there is a scheme where you will see how does it work. Can I have the next slide, please? Yes. You see, first you have individuals who are victim of their stolen identity or identity cards. Then the individuals who stole the identity open account with online banks or institutional financial institution. And what they do, they lend, they borrow money to bank who will send the money on the online bank's accounts. Of course, they will never reimburse the loans, but they will get the money thanks to the stolen identity or stolen information from victims. And this is a very common scheme of money laundering. If you stay in the same register, you have heard about the Wirecard scandal. The amount of the fraud is evaluated to about 1.9 billion of euros. And Wirecard is online financial institution. That is the topic of, we won't go into the detail because it's very new and the German police doesn't exactly know how the things happened. But the thing is that Wirecard was between the customer and the bank. And the role was to facilitate the payment, especially for people who didn't have bank accounts. And some of the employees or managers of Wirecard have forged false documentation in order to divert money from the bank to offshore companies. And so the fraud is huge fraud, and the problem is that the BaFin, who is the German regulatory authority, didn't see anything in the fraud, and the auditors didn't see the fraud either. And today we have to face, or German authority have to face, 1.9 billion euros fraud. Next slide, please. Insurance sector is also subject to money laundering, and the thing is that it's more an abuse of corporate assets that revealed by multiple contracts of insurance policies subscribed for luxury goods. For example, you have acquisition of vehicles and pieces of art not contributed to the achievement of the company's corporate purpose, but you have private insurance of those cars for the people who drive the cars. And you will also find abuse of company funds for the benefit of other companies, debtor partner current accounts, account reclassification. This is a classical scheme of money laundering. Next slide, please. Non. Nicolette, on peut voir la slide. Voilà. You see in the scheme, well, how does it work? It's paid by the company, insured by the company, but used by someone else. Next slide. Those examples are, by the way, those examples are given by TRACFIN, who is the agency, French agency, that is in charge of fighting money laundering. And it's and although that received the declaration of suspicion, so they collect information and they have now very huge base of information, and they can identify a scheme of money laundering and detect those money laundering operation. And there is another tax evasion example where you have some money laundering mixed. It's called the Dom-Tom, not Dom-Com, Dom-Tom Girardin tax evasion scheme. We have in France some territoires d'outre-mer, like La Réunion, Guadeloupe, Martinique, and in order to stimulate the development of those territories, people can invest, and if they invest in those territories, they can benefit of tax deduction. So you have some next slide, please. So the idea is to collect the money, to get the tax reduction, but the money, instead of going to the company that is supposed to invest in the territory, like to I don't know how to say panel photovoltaic, that to a unity that produce solar energy, they do not invest and keep the money, or they invest part of it only. So this is another way to give the appearance of a regular operation, but in fact it's a tax evasion or money laundering operation. So this is a few examples of money laundering operation, and of course one of the key problem is the use of financial institution or a bank, especially some online bank like Wirecard, as we say recently. And you have, although it's sometimes very difficult to combat money laundering, because you have to face with some specific regulation. I give you an example to finish about the data protection regulation. When we have the terrorism attentat in Paris of the Bataclan, the policemen made deep investigation, and they realized that one of the authors of the attentat in Bataclan bought a Kalashnikov with credits granted by a bank specialized in consumption credit. What happened is that the guy was client of bank that closed the account because of terrorist suspicion. But then he opened another account in a subsidiary of the banking group. But because of the data protection, the bank who closed the account could not inform the sister company that it has closed the account for terrorist financing suspicion. And so the guy could get a loan from the company. It was a bank would have a small license just to grant some small loans, and he could get the loan from this sister company without being detected, and he could bought the Kalashnikov with the loan. So okay. It's very complex to combat, and you need to gather very large information.
Thank you very much, Silvestre, for your speech and for your very interesting example. Please note the last slide of Silvestre. Any question? So if you have any question, please you can write your question or also consideration with the chat. So before the last speech, I would highlight that UIA is a very open organization, and it is possible to cooperate also with our organization to organize webinars, to write articles, and so on. We are very lucky because Etienne Lesage, it is the president of the Criminal Law Commission. So Etienne, I ask you if you can say some words about the activity of your commission. So, for instance, as a member of UIA, can cooperate with you.
Yes, thank you, Barbara. The Criminal Commission is a big commission of the UIA because there are many members, around 200 or more, and coming from, of course, all across the globe. And we were very happy to go to Mexico, Guadalajara Congress next for our annual Congress next October, November, but that will be then in 2021, like all our webinars. We have organized 2 webinars since the lockdown that unfortunately has stopped our seminars, but each time, and today it is the same, thanks to you, Barbara, we have many of our colleagues, many of our members, many of our future members who are following us, and especially today on that very important topic. So the Criminal Commission is really would like, and will be happy to work with other commissions that we do already, like the Tax Law Commission, on a certain number of topics, like other commission, the Arbitration Law Commission as well, that we organize joint seminars in the future to give the opportunity for our colleagues and for our future colleagues to be interested in our joint seminars. So welcome to all the future members, all the criminal lawyers, whether they are corporate law criminal lawyers, whether they are human rights lawyers. Gustavo, with the UIA, IROL, we have many linked together. We can work with the Human Rights Commission. We have to work with IROL, of course, because we intervene in the same topics.
Okay, thank you very much. Thank you very much, Etienne. I remember also that as a UIA member, you can cooperate also to write articles, short article, for instance, for our newsletter, or also article more complex for Juris Internationale. It is a very interesting review of the UIA. So the last speaker is my friend and colleague Yonca Fatma-Yücel, because we are in the same commission. It is the Banking and Financial Service Law Commission, and we work together often. So I introduce yourself, Yonca. Yonca is Turkish, and she's Vice President of the UIA Banking and Financial Service Law Commission. She's an in-house counselor and a Chief Senior Specialist in Law, Banking Regulation and Supervision Agency in Turkey. I remember the key point of the speech of Yonca, that is the 5th Anti-Money Laundering Directive and the legal application of Payment Service Directive 2 in Turkey. So in the speech of Yonca, there are also links between European Union law and Turkish law. I like the title of the speech of Yonca, that is a speech that describe the banking and financial point of view and the link with money laundering and terrorist financing. The title is a general overview of precaution against money laundering within the framework of Payment Service Directive 2 and banking application in Turkey. Please, Yonca.
Thank you, Barbara. Good evening, dear friends, dear colleagues. I would like to present the general overview of 5th AML directive, what the open banking system offers, Turkish law and relevant regulation related to payment services and electronic money institutions, and relevant provisions of Turkish legislation's compliance with the EU AML directives. Next slide, please. At that point, I would like to introduce the 5th Money Laundering Directive. 5th Money Laundering Directive was entered into force 10th of January. under the Article 4 titled Transposition for all EU member states. Nevertheless, I would like to emphasize that the effective date of Article 31st was 10th of March, and Article 32A, which is related to centralized automated mechanism, will be 10th of September. In the circumstances, which key subjects changes the 5th AML brings compared to its precedent 4th AML? Cryptocurrency, prepaid cards, beneficial ownership, high-risk third countries, politically exposed persons. I would like to emphasize that 5th AML reinforces the European Union's AML CFT regime to address a number of emergent and ongoing issues. Main provisions are as follows: expanding AML regulations to lettings agencies where the rent is over 10,000 euro per month. Also regulating virtual currency exchange and the wallet providers. Updating CDD rules to reflect the increasing use of electronic due diligence. The requirement of pay attention to beneficial ownership details and regarding towards occurred discrepancies during doing the CDD. Government will have to produce list of public functions toward PAP, publishing compliance monitoring report like SRA by regulatory bodies. At that point, let's more focus cryptocurrency within this framework PSD2 directive. 5th AMLD makes a significant new legislative step in the treatment of virtual currencies. I would like to emphasize that a legal definition of cryptocurrency, which may broadly be regarded as a digital representation of value that can be digital transferred, stored or traded, and is accepted as a medium of exchange under the Article 3. Cryptocurrencies and the cryptocurrencies exchange are considered obliged entities and face the same CFT AML regulations applied to financial institutions under 4th AMLD. 5th AMLD actually goes further than 3rd AMLD in imposing reporting obligations by giving financial intelligence units the authority to obtain the addresses and identifiers of owners of virtual currency, and in so doing, to push back against the anonymity associated with the use of cryptocurrency. Last thing goes that 5th AMLD also introduces regulation for providers of cryptocurrency exchange and wallets, which must now be registered with the competent authorities in their domestic locations, such as BaFin. Next slide, please. No, before. Ladies and gentlemen, I would like to introduce the main functional interfaces AIPCPC and PICPC of Open Banking under Payment Services Directive 2. What the Open Banking offers. As you see the picture, Open Banking system includes two legs, which is called Payment Initiation Service Providers, PICP, and Account Information Service Providers, AICP. Let's look at the operation of mechanism. In this system, AIP layer, which retains and stores up customers' account, all personal info, circumstances, bank's relationship, financial analysis, movements, regular transfers, credit transfers, current investment analysis, reporting for family balance, commercial transactions, investments, payments, and donations. At that point, main working principle of open banking under PSD2 depends on to get access permission of third-party service providers from bank for customers' financial data. That means mentioned financial data can be easily shared among all financial institutions through AIP and can be accessed by third-party service providers with the permission of the customers. Banks and fintech companies can analyze data such as client spending and investment habits and their current financial capacity with the data accessed via API. These analyses can be shared with the clients to determine the most appropriate strategies, products, and offers compliant with their actual needs. That's the most important thing that I would like to highlight, that clients will be able to manage their all banking transactions or investments through mentioned a single application or website. Next slide, please. As you see the picture, you can see the sample working style of the PSD2. With regard to PSD2, I would like to introduce the Turkish legislation compliance with the PSD2, titled Law on Payment and Security Settlement Systems, Payment Services and Electronic Money Institutions, and Regulation on Banks, IT Systems and Electronic Banking Services. For ensuring compliance with the PSD2 in Turkey, on November 22nd, 2019, the Turkish Grand National Assembly codified open banking by introducing the amendments to the law on payment and securities settlement systems, payment services, and electronic money institutions, prepared by Turkish BRSA. The law defined and implemented PICPC and the AIPCP and their legal backgrounds. In terms of providing these services under the law, service providers shall obtain an operating permit from the Central Bank of the Republic of Turkey. 3 months later, BRSA issued regulation on banks' IT systems and electronic banking services on 15 of March based on mentioned law. This regulation includes lots of important provisions, but due to its special ties, that I would like to share some provisions as follows. For instance, composing and following up on the trail records, management of the outsourcing process for getting services, including establishing iClose systems from third-party service providers, general transaction principle of electronic distribution channels, and ensuring required checks and balances regarding to access customers' financial data, including sensitive data, before the mobile applications for verification and transaction security, electronic transmission of sensitive data and customer secrecy, such as account statement extracts for informing customer, verification, transaction security, and service quality before mobile banking, verification and transaction security before ATMC. Those articles were entered into force 1st of July, and on that day, former regulation on banks' IT systems was abolished. I'm pleased to inform you that the another provisions of the regulation will be entering into force on 1st of January 2021. Next slide, please. At that point, I would like to introduce the relevant provisions of Turkish legislation's compliance with the EU AML directives. Ladies and gentlemen, let's return to the payment services providers and electronic money institutions. They are considered as financial institutions and obliged parties, or in other words, obliged entities, under regulation on measures regarding prevention of laundering, proceeds of crime, and financing of terrorism. All financial institutions, including payment service providers and electronic money institutions, are subjected to principles regarding customer due diligence identification. Within this framework, dealers of precious metals, stones, and jewelries as obliged parties are subject to the same principles. Moreover, all financial institutions shall take required measures against technological risks and be subject to the principle on reliance on third party under mentioned regulation. Payment institutions and e-money institutions shall assign exclusive compliance officer at administrative level within the 30 days following obtaining an operating license under regulation on program of compliance with the obligations of anti-money laundering and combating the financing of terrorism. Next slide, please. Next slide, please. Ladies and gentlemen, I would like to introduce the General Communique number 5, prepared for Financial Crimes Institute. It includes so important measures, titled Simplified Measures. What the important simplified measures? Simplified measures within the scope of CDD are subject to the same restrictions such as customer identification, identification beneficial owner, under above mentioned regulation based on the transactions type, which carries on low risks. But I would like to emphasize that obliged parties shall assess each transaction separately, whether there will be any abuse of transaction for money laundering and terrorist financing, and therefore whether there is any risk of money laundering or terrorist financing. In case of there is a suspicious transaction or suspicious money laundering or terrorist financing, obliged parties shall not apply simplified measures and shall report the transactions to the Turkish FIU as an STR. But under the subparagraph 2 to 11, titled for transactions related to payments and electronic money institutions that I would like to share with you, under the subparagraph, obliged parties pursuant to law 6493 may not apply customer identification for issuing electronic money and payment services used only for the purpose of purchasing goods and services. For applying simplified measures, obliged parties shall consider the aim of procuring electronic money provided not exceeding cash withdrawal in the same year in the amount of 38 euro and is found in the amount of 95 euro, whether stored electronically or reloaded, or transactions volume not exceeding either the amount 38 euro for single transaction or the amount of 95 euro monthly transaction. Regarding mobile payment services via rendering electronic communication services under Article 12(1)(d). In terms of issuing non-face-to-face electronic money which exceeds the specified amount in electronic environment via electronic account membership, obliged parties may not be obliged to identify information of the customer, provided that to keep both required identity information for both natural person or representative legal person, and to ensure all collections and payments through a bank or credit card amount watching with the verified identity information of the person who has been accredited with the electronic account membership. Within the paragraph, within the scope of subparagraphs A and B of paragraph 1 of the Article 12 of the law, the measures stated in the second paragraph may be applied to the customers of the payment service provider which serves through electronic terminal service, regardless of the amounts of the transactions. Next slide, please. Next slide. No, before, yes. No, next slide. Barbara, yes.
No, I don't have the control.
Yeah. Let's come to the point, general overview of regulation on banks' IT systems and the electronic banking services based on the CDD. I think the main provisions, main special provisions are as follows. Although all cryptocurrency-based financial facilities and activities, including Bitcoin, are likely to be considered among the assets which are defined in the law as not suitable for the nature of the cryptocurrency and sources of which are illegal. But I would like to emphasize that although this provision, the law on payments and security settlement systems, payment services, electronic money institutions, and our regulations are in compliance with the PCD2. And another point goes that our mentioned regulation includes two-factor authentication and essential IT systems check and balances towards electronic banking services in compliance with the principle of CDD under EU AML regulations. But I would like to share with you the special provisions in regulation is as follows. Titled Remote Identifying Customers' Identity and Reliance on Third Party. Under the Article 43, banks may use the remote method for identifying customers' identity or to be taken service from the other bank which already identified and verified it via open banking system, with the aim of identifying the identity of customer or those who act on behalf of the customer, provided that obligations are reserved which has arisen from law on prevention of laundering proceeds of crime and relevant regulations and communique. These principles of procedures related to these articles shall be set by the BRSA board. Ladies, with you, this article has not entered into force. As I understood, this article will be entered into force 1st of January 2021. Thank you for your kindly attention.
Thank you very much, Yonka. So before concluding the webinar, I read another question. I don't know if Yonka can you read the question?
Yes.
I don't. Oh, I summarize the question because it is very interesting. It is a question that concerns the United Nations. The United States, when the United States imposed the sanction. I read the example that is very clear. Our colleague brought this example. United States imposed a sanction against some Syrian political and officers. So sanction against officer or men of Syria. But some banks extend sanction to include all Syrian people. So, our colleague asked why some banks do such conduct in your opinion. I can reply with in this way. The bank have to observe the rule that concern embargo, because when you write your United States sanction, there are specific rules that are connected with embargo, that are international rule, and the bank have to observe this rule, because otherwise the sanctions for the bank are very, very high. Please note another consideration. You are right why some banks do such conduct in your opinion, with reference to sanction but that means embargo. Please note that the bank are free to be more conservative. For instance, in the case of high-risk country. High-risk country is very important to know the list of high-risk country for an ML point of view. But for instance, European Union, we have a regulation, the regulation 1675, that indicate the list of countries that are considered high risk for the European Union. But for instance, an Italian bank, I'm Italian, an Italian bank can be considered the list of European Union, but also other country. It can introduce in the list of high risk country, the countries that are in the list of the European Union, because the Italian bank has to observe the European Union rule, but also other banks. Other example, a bank can decide if to open an account to natural person or not. This is also for reputational. This is also from for a reputational point of view. So the bank can decide. But the bank is relevant that the bank has to observe the rule that concern embargo, that concern anti-money laundering, and the combating the financing of terrorism. This is important because the sanctions for banks are very, very high. So I don't know if Yonca, Silvestre.
Yes.
Okay, Yonca, please.
Yeah, although Turkey has not yet the European Union member, but interesting point that I would like to emphasize, because Turkey has obeyed to all FATF rules. Turkey is a member of FATF. For that reason, all regulations regarding the money laundering and terrorism financing, I think, are in compliance with the FATF rules and the United Nations principles and the EU directives. For that reason, for instance, if the FATF, determined the one country is called the high-risk countries, and all Turkish banks, I think, obeyed these rules, because our law, our the regulation, and our money laundering and terrorism financing law determined the so exact principles. For that reason, if the bank does not obey these rules, I think bank will not do any transactions, international transactions, not only national transactions but also international transactions. For that reason, we loyal all FATF rules and United Nations principles and the EU directives.
Okay, Yonca, thank you very much for this. There is another question. I don't know if speaker would like to reply, because there is a question that concerns always the banking and financial sector. And our colleague asked us, do you think that banking secrecy will reduce or disappear in the next coming days based on AML requirement?
Yes.
Silvestre, if you want to.
Yes, it will reduce. Yes, certainly the banking secrecy will be reduced. and strongly, it will not necessarily totally disappear, but the scope of the banking secrecy will be reduced, like as we say in French, peau de chagrin. See, it will reduce. Yes, certainly.
And
Yonca, please.
Yeah, and add something. You know, interesting matter. You know, those 6 months ago, Turkish BRSA, Turkish Banking Regulation Agency, brought the new law, and I think this law defined the customer secrecy. I think the Turkish BRSA defined the first step, first at all, the customer secrecy. I think, in my opinion, no countries define the customer secrecy what it is, but we encourage the all countries, because we are regulate the another framework within the compliance with the customer secrecy, and I will prepare the regulation based on these items. For that reason, I think, yes, I agree with the Silvestre, but time to time, if you don't determine what it does, I think you cannot visualize the further steps.
Okay, thank you very much, Yonca, for your reply. So we have to conclude our webinar, but before I have to thank you very much, Colette Sourin. Colette Sourin is in the staff of the Union Internationale des Avocats. Thank you very much, Colette, for your assistance. You are very, very important for us. Thank you very much. And yeah, and thank you very much to Etienne Lesage, to Gustavo Salas Rodriguez, to Silvestre de MARSAC, to Yonca Fatma Yücel for your fantastic and very interesting speeches, and also for your activity in the Union Internationale des Avocats. But I have also to thanks to our participant. I would like to read the country of our participant, because the participants come from all over the world. I read: Dominican Republic, United States, Bolivia, India, Spain, Poland, Germany, Bahrain, Italy, Cameroon, United Kingdom, Congo, France, Romania, Belgium, Sweden, Portugal, Burundi, Luxembourg, Algeria, Guinea, Switzerland, Kuwait, Lebanon, Haiti, Egypt, Niger, Pakistan, Brazil, Canada, Turkey, Morocco, Mexico, Ecuador, Panama, Angola, and Mali. Thank you very much for your participation to our webinar. Thank you very much. Ciao. Hi.
Ciao. Thank you, Barbara.
Thank you very much. Bye.
Thank you, Colette. Thank you to all. Bye-bye.
Bye.
Bye-bye.
Thank you all.